Hi, I am Mary Hilary O. Luces, and I am the fifth reporter of Chapter 3. On the application of the purchaser of a partner's interest in a partnership, if ever man naibenta ng isang partner yung interest niya sa partnership, the purchaser or assignee, which is yung bumili ng interest ni partner, has no right na i-terminate or i-dissolve yung partnership kung ongoing na ito. However, kung natapos na ang contract and hindi pa din na-dissolve yung partnership, that's the time na pwede nang mag-request yung assignee sa court na i-dissolve yung partnership. For example, ako si Marjorie tsaka si Rodessa nag-agree na itatag yung MHR partnership for construction of a 3-floor building that we will use for our own businesses. So we decided to contribute equally so the partnership can be formed. However, sa kalagitnaan ng contract, binenta ni Rodessa yung interest or share niya kay Jenny. That's why Jenny became an assignee. Since ongoing pa din yung pagpapatayo ng building, Jenny cannot ask or request for the partnership to be dissolved. The only time that she could ask the court to dissolve the partnership is when the purpose of the contract has been made. So sa Article 1832 naman, it talks about the effects of dissolution or winding up in terms of authority of a partners to represent the partnership. So, kapag on process na kasi ang dissolution or winding up ng isang partnership, all of the partners will lose the authority to represent the partnership. However, meron tayong tinatawag na liquidating partner. So, si liquidating partner na lang yung may authority na i-represent si partnership sa transactions or any contract. Usually, yung transactions na ginagawa ni liquidating partner is sinisettle na lang yung non-cash inventories as well as yung other properties of the partnership. So, si liquidating partner na din yung nagre-represent sa partnership para ma-fulfill or matapos yung mga contract na that they signed before the dissolution of the partnership. So, because the liquidating partner na lang has the only authority to represent the partnership, all of the transaction or contract should be done with respect to the partners when the dissolution is not by the act, insolvency, or death of a partner, or when the dissolution is by such act, insolvency, or death of a partner in cases where Article 1833 so requires, or with respect to persons not partners as declared in Article 1834. Sa Article 1833 naman, it talks about the exception on the general rule. Generally, when a partner or the acting partner of the partnership enters into a new contract with a third person right after the dissolution of the partnership, the new contract will bind the partners to it, as if the partnership wasn't dissolved or winding up. But there are two exceptions on the rule, which is number 1, the dissolution being by act of any partner. The partner acting for the partnership had knowledge of the dissolution. As you can see, the acting partner is in bad faith. He has the knowledge about the dissolution already, pero pumasok pa rin siya sa bagong kontrata. Since the contract was made by the acting partner that is in bad faith, it will not bind the partners that are innocent on the contract. So those partners na walang alam about the dissolution of or winding up of the partnership will not be bind on that contract since it was performed on bad faith. Number 2 naman, the dissolution being by the death or insolvency of a partner. The partner acting for the partnership had knowledge or notice of the death or insolvency. Sa number 2 naman, the innocent partner who don't have any knowledge or notified about the death or insolvency of the other partner won't be bind on the contract. Same lang siya ng number 1. So, yung purpose ng Article 1833 is to protect innocent partners to those partners who performs bad faith. Sa Article 1834 naman, it talks about the relation of the acting partner with the partnership. General rule is di na pwede makipag-transact yung partners pag dissolve na yung partnership. Ang exception is kapag yung related transaction is for winding up. By any act appropriate for winding up partnership affairs or completing transaction unfinished at dissolution. Dito, pwede makipag-transact yung acting partner as long as for winding up ng partnership and tinatapos na lang niya lahat ng unfinished transactions or contracts na sinimulan before the dissolution. So number 2 naman, by any transaction which would bind the partnership if dissolution had not taken place provided the other party to the transaction. Liable pa din si partnership kasi dito pumapasok yung mga transaction ng partnership na hindi pa na-fulfill pero na-dissolve na si partnership. So sa letter A, the third party is in good faith since hindi naman niya alam yung dissolution ng partnership. So meaning liable pa din si partnership sa kanya. Sa B naman, same lang siya ng A, ang kaso may exception. Kung in-advertise ng partners sa newspaper or vinod ka sa any social media platforms yung dissolution ng partnership nila, that's the time na hindi na liable si partnership sa kanila. Sa part naman nito, ito yung mga exemptions kung bakit hindi na liable si partnership sa contract. 1. Dissolve because of unlawful acts. Yung isang partner nagbenta pa din ng product kahit na dissolve na yung partnership nila because of unlawful to carry on the business. So this is the time na hindi na liable si partnership because in bad faith na yung isang partner. Number 2 naman, where the partner has become insolvent. So this is the time na na-dissolve yung partnership dahil one of the partners became insolvent. Tapos yung insolvent partner, pumasok siya sa panibagong kontrata. So usually hindi na magiging liable yung partnership dito kasi he is the reason kung bakit na-dissolve yung partnership nila. Number 3 naman, where the partner has no authority to wind up partnership affairs. So ito yung nakipag-transact yung isang partner but he has no longer authority to represent the partnership on any transaction or contract. So the partnership will not be liable on it unless the third party has knowledge about the dissolution, which pumapasok sa paragraph number 1. Take note that nothing in this article shall affect the liability under Article 1825 of any person who after dissolution represents himself or consents to another representing him as a partner in a partnership engaged in carrying business. So, partnership is liable only if act appropriate for winding up partnership affairs. Even though na-dissolve na yung partnership, meron pa rin isang partner that will sold the non-cash asset of the partnership, including other inventories and PPEs. This transaction is still binding to the partnership. Number 2, act for completing transaction unfinished at dissolution. So even the partnership is dissolved, meron pa rin mga undelivered goods and inventories sa mga clients that needs to be delivered since hindi pa natatapos yung contract na pinirmahan ng partnership before dissolution. Number 3, any transaction which would bind the partnership if dissolution had not taken place provided the other parts of the transaction. If a partnership purchased goods on credit before dissolving the partnership, they are still liable to pay the creditor for he has knowledge about the dissolution of the partnership already. So there are times na meron tayong napapanood na mga bangko or even those company that went to bankruptcy. The reason kung bakit nila kung bakit nila brino-broadcast sa public na bankrupt na sila is to let every creditor, suppliers, or even the customers knows that the partnership is already dissolved. If ever na hindi i-broadcast or even i-advertise sa newspaper, tapos nakipag-transact pa rin yung isang partner sa dating supplier ng partnership, the partnership is still liable to the supplier because he has no knowledge about the dissolution of the partnership. If ever na-broadcast naman yung dissolution, the partnership will not be liable. After the partnership is already dissolved, it is no longer liable if the partnership was dissolved because it was unlawful to carry on the business. So there are instances na merong mga business na napapasara o kaya naman merong mga product na kinukumpiska because it contains harmful elements from the skin. If ever man naibenta pa rin ito ng isang partner after the dissolution of the partnership, hindi na magiging liable yung partnership because it was completely an act of bad faith on the side of the partner. Unless the act is appropriate for winding up partnership affairs, magiging liable lang yung act kung parte ng winding up partnership affairs yung ginagawa ng isang partner. Second is where the partner has become insolvent. Another reason kung bakit nadidissolve yung partnership is one of the partner announced he's insolvent, that he can no longer pay his obligation to the partnership. So, kapag na-dissolve na yung partnership because of insolvency of a partner, tas yung insolvent partner naman, he entered in another contract, the partnership will no longer liable. Because unang-una, the contract was made after the dissolution, and another factor is that the insolvent partner is the one who entered in the contract. Number 3, the partner had no authority to wind up partnership affairs by a transaction with a third person who's in good faith. So every partnership dissolution and winding up has a liquidating partner. Like what I've said earlier, the liquidating partner is the one who has authority to represent the partnership. So he's the one who sells all the non-cash and other assets. If ever man na makipag transact yung another partner with their previous supplier after the dissolution, and the partner bought supplies on credit, if the supplier has no knowledge about the dissolution, the partnership is still liable. But if the dissolution have been advertised or broadcast, ito yung sinasabi ko kanina, that's the time na hindi na magiging liable yung partnership kasi na-broadcast na or na-announce na ng mga partner na their partnership is already dissolved. So, sa Article 1835, when a partnership is already dissolved and it still has obligations and liabilities that needs to be settled, the partner cannot be discharged on his obligation as a partner or a part owner of the partnership. So, kailangan pag-usapan ng mga partners kasama na din yung mga creditors ng partnership to discuss the proper settlement on how will they satisfy those remaining obligations. So, these obligations incurred before the dissolution, that's why a partner cannot escape or discharge himself from the liabilities. So, even if the partner is already dead, he still needs to satisfy his liability by using a separate property. Ito yung mga private property ni partner. But there's a condition, and it needs to be followed on using the deceased partner's private property. So, kailangan mo nang mabayaran yung mga personal debts ni partner. Then, kung ano man yung matitira sa mga private property niya, ito yung gagamitin to satisfy his shared liability and obligation inside the partnership. So, for example, X, Y, and Z formed a partnership, but it was immediately dissolved because X died. So, other than A, which is the creditor of XYZ partnership, meron pang standing liability si X kay B. That's why gagamitin yung separate property or yung private property ni X to pay his liability. However, kailangan mo nang mabayaran yung utang ni X kay B, then the remaining share of the property of X will be used to pay his liability to A. Then, there were a time na the partner's liability is discharged. So, in order for this to happen, the partner, other partners, and the creditors of the partnership should agree to discharge the liability of a partner when the partnership is in dissolution or winding up. That will be all, and thank you.